SwayamPrabha. Digital India. Educated India.
Welcome viewers, this is Dr. Ashwini Sifal from Faculty of Law, University of Delhi. I am with you today to discuss a very important topic called Law and AI, and we will emphasize on the definition, scope and contemporary relevance of this particular topic in our series called Law, Science and Technology. Well viewers, this is lecture number 6 of this series, and we will have 2 more lectures on AI, or specifically on AI and law, wherein we will discuss the AI's scope in the Indian legal justice system or Indian legal education system. But here in this lecture we will focus specifically on the definition, scope and contemporary relevance of the AI in the field of law. Well viewers, as you all have been hearing, and you must have been seeing that there has come a dramatic change in the way the legal education, the legal system works in our country, and specifically the notable development is the involvement of the or indulgence of the AI or the tools, AI tools or AI devices for upgrading knowledge, for even adducing evidences, for even contesting court suits in the courts of law in the country. So over the period of time, the AI has become very relevant in the legal field, and it is onerous for any law student studying law to understand its implications and its efficacious uses in the field of the law or in the field of legal system or criminal justice system, or be it civil justice system. So my dear viewers, with this small backdrop, I would like to discuss the definitional contours of AI, the scope of AI in the field of law, and its contemporary relevance in the field of law. And I have specifically designed this lecture for those students who are interested in interdisciplinary studies of law and science on the other hand, or technology on the other hand. And I know that this course, Law, Science and Technology, is offered worldwide in many reputed institutions, in the law schools of many reputed institutions including India, and lot of law schools offer this course as an elective, or at some places it is a compulsory course for the law students. So if your law course is designed and it does not include AI and its interface with the law, then it is perhaps not complete. So it is important that the viewers here delve into the aspects of law and AI, their scope, their relevance and the definition. So we will have following things will cover today in our discussion for 1 hour. What is AI? What are the different approaches? How AI is implemented, or how does it work? Then we will also discuss the current policy issues in AI and law. We will see how the policy framework is being articulated and designed, because at the end of the day it largely depends on the policy framework. If the policy framework pertaining to a particular discipline is not efficacious, its implementation will remain bleak, or you may say its efficacy or its potency shall not see its zenith, right. So we will also have a look at how AI functions and how it is used in the context of specifically law, right. Then we will demystify the notions about AI and its uses in the field of law, because at times the traditionalist approach, or the lawyers with the traditionalist approach, they argue that this AI may gonna replace the humans or the lawyers, or even the law fraternity at times feel threatened because of its omnipresence in the legal justice system or in the legal education system. So we will demystify it, whether it really will replace or not. Then we will have a look at some pros and cons of the AI as such in the field of law. This is how I have designed this lecture. So let us friends begin with some important definitions about the AI. First I will cover the AI, and then I will go back to scope, and I will go back to the approaches in which the AI functions. So far as the definition is concerned, it is one remarkable solution in the field of legal industry these days, and it is basically automated machines, and the reliance on one or more machines, even for the smallest of the tasks, is basically done in the field of AI. In the common parlance, artificial intelligence can be described in contrast to natural intelligence by humans as machinery or robotic system of providing quick and prompt solutions. AI is a rapidly advancing field of computer science. In the mid 50s, when John McCarthy, who has been credited as the father of AI, he defined it as the science and engineering of making intelligent machines. So it is at the end of the day a machine or some device or a tool or maybe a robot, but it has some intelligence in it, some cognition in it, and that cognition can never come or cope up or can perhaps not come at par with the cognition of the humans, but it is not too far when it comes to the comparison of the human cognitions or the machine cognitions. There are instances where machines specifically based on ML model, they are learning on their own, and they are generating or gaining lot of knowledge and intelligence, and machines are developing their knowledge system on their own. So this is something basically science and engineering basically, which makes the machines intelligent. Conceptually, AI is the ability of a machine to perceive and respond to its environment independently and perform tasks that would typically require human intelligence and decision making processes, but without direct human intervention. So here we are seeing that AI has developed to the extent where it does not even require human intervention these days, and it is just typically working or functioning on its own, and which is worrying, and which basically leads to that threat or apprehension of some traditionalist school of thoughts, that whether the machines will replace us tomorrow. But I believe these machines are really helpful, and they can definitely be a great asset in the field of law, in the legal practice, in the legal judgment writing, in the legal plaint making, etc., or legal draft making, etc. We will see those kind of usages or advantages of AI, but our purpose here is to understand more on the definitional contours of the AI in the field of law. Well, artificial intelligence is the ability of a digital computer to or computer controlled robot to perform tasks commonly associated with intelligent beings. The term is frequently applied to the project of developing systems endowed with intellectual processes, characteristics of humans, such as the ability to reason, discover, generalize, or learn from the past experience. So this is the definition given by Copeland of the artificial intelligence. We have a few more dictionary definitions available. In the Oxford Dictionary, it has been defined as the theory and development of computer systems able to perform tasks normally requiring human intelligence, such as visual perception, speed recognition, decision making, translation between languages. And my dear viewers, every such feature which it possesses, like perception, speech recognition, and decision making and translation, or learning from the past, all may be used in the legal field for for some purposes, and especially for expediting the legal field, which is snail paced. We all have seen, and we all see that how effectively the virtual courts worked in the times of COVID, and we all know that during that time, because of the virtualization or because of the use of the technologies, the pendency in the cases drastically reduced, and the usage of the technologies may also further reduce the pendency in the cases, which is one such shortcoming, and it is a long pending shortcoming in the field of judiciary or in the field of legal justice system, where the cases are not decided on time, and the civil suits and the criminal suits, they languish in the courts of law for years together. So artificial intelligence and its features like perception, recognition, decision making, translation, and drafting, like these new LML models of ChatGPT or such tools may be used for drafting, etc. An area, it is basically an area, according to Merriam Dictionary of Computer Science, that deals with giving machines the ability to seem like they have human intelligence. So some dictionaries have compared it to a human intelligence, or they have analyzed it with the human intelligence, but it is also true at the same time that it is not up to that cognitive level which the humans possess, but or humans do possess, but it is not far away. Then we have a definition given under the Collins dictionary. It is a type of computer technology which is concerned with making machines carry out work in an intelligent way, similar to the way a human would. So everywhere you see that it is being compared even in the definitional aspects with the human intelligence. In short, artificial intelligence is the ability of a machine to think and act like humans, or replicate cognitive functions that humans associate with other human minds, such as learning and problem solving. So it has all such features, or it has advanced to the extent of possessing all such or manifesting all such features. So in light of this definitional background, I believe that we now need to see what are the different approaches on which the AI function, because those approaches are very important for us to understand, so that we can have the appropriate application of this technology in the field of law, and we can understand which particular approach is more clinching vis-a-vis to another. So coming to the approaches, this basically runs on two approaches broadly, right. One is logic approach or rule based approach, another is machine learning approach. So far as machine learning approach is concerned, it is more advanced in comparison with the former, because former is broadly a rule based and it has it does not have its own learning skill. On the contrary, the later, that is machine learning approach, on which the AI functions, it has its own knowledge acquiring system, because here in this case we go by the top down approach, and here in the logic based approach, the AI functions on the logic fed into it. But on the contrary, in the later approach, the machine learning approach, where there are definitely the algorithms or initial algorithms which are fed, but it learn through patterns, it learn on its own. So that makes the second approach more viable, more advanced, and more usable in the context of legal field as well, and even otherwise. So if we see that there are some couple of models where hybrid systems or hybrid AIs are used, using both the approaches, that is rule based as well as the machine learning based, and this brings that apprehension of basically changing the human or replacing the human, or enhancing its role in the society or in the legal system, or role of AI in the legal system. So hybrid systems are efficacious, but yet they haven't reached to that extent of replacing the humans. So it is abstract theory that they will gonna replace humans, or it may be true, because I come from a legal background, so I don't know much about the advancement in this field and the future speculatives or speculations in the field. But so far as this particular at this juncture, I mean the level of this technology is concerned, it is to a great advancement, and we see that its use is very important in the field of law, and its basically its advantages should be used in the field of law, so that some shortcomings in the or drawbacks in the field of law should be catered to or addressed. Now coming to scope in the field of law today, it may be used by the lawmakers, by the police, by the administrators, that is the judges. It may be used by the practitioners, attorneys, law firms, for the case management, for computable contract making, for automated document analysis, for legal research, and users of law, maybe anybody, the ordinary people or the individuals as well as the body corporates. So it has a great usage in the field of law, and its scope is very broad. The only problem is that right now there are a lot of myths which I will try to demystify at the end of this lecture, which are prevailing among the legal fraternity while using the AI. There have been couple of instances where the judges have written the judgments based on the AI or by using the AI tools, or they have observed or given their keen observations that judgments may be written by the AI tools. So scope of the AI in the field of law is immense, and it is only the regulatory models which should be which should be efficacious to make its best use and to make its best usage in the field of law or legal fraternity by the legal fraternity. We have seen the definitions. Now coming to the challenges which are faced by the legal practitioners, and where we may perhaps plug in the AI or the tools of AI to sort out these challenges or to address these challenges. They have to go through the vast amount of data to find relevant information. We lawyers have really need to read a lot when it comes to any particular subject of law, and we have to make our reading vast in the cases of preparing the litigation or in the preparing of the matters which is listed in the courts of law. And usually the courts of law which are overwhelmed and overburdened with the cases, they do not give us much time, though there takes place or there are taking place a lot of adjournments, and courts are known for adjournments, for different tarikhs to be given by the courts, but yet the courts prefer to or strive to reduce the adjournment or reduce the delay. So in that case or in that context, AI or the tools of AI may become very useful, and they may be used for reviewing or analyzing the vast amount of data, and to ultimately find the relevant information from that vast amount of data. Then in the cases of humans, the error in the drafting may occur, but when the machines will draft the things, there is rarely any chance of any error to be committed by the machine, unless that machine has been fed wrongly. Otherwise it will be impeccable in its results. Then case study is time consuming. We see that voluminous cases are being written, or voluminous orders are written by the courts of law, spreading across 1000 pages or 2000 pages at times. So that kind of culture in the legal field is restrictive in nature, because no lawyer has the time to read 2000 pages judgment or 1000 pages judgment, and what he desires at the end of the day from the judgment is the particular law in question, is the application of the law in a particular case, or interpretation given by the law in a particular case by the judiciary, and the final outcome. Or in the legal terminology, we can say they just look at the factual metrics, they just look at the law attracted in a particular case. Also they look at the ratio or obiter in a particular case, or some cross references they refer to. When it comes to ratio in a particular case, the the lawyer's attention, or lawyer's purpose is to have a look at the rationale on the basis of which the case has been decided, or his purpose is to see the justification of a particular application of a law. So all those things require a lot of time and energy on the part of the lawyers, because they have to study a lot, but these tools may be used for the purposes of reducing the time, which is a vast amount of time which gets spent in reading literature, in reading case studies, etc. Then coming to efficiency in terms of cost, as I told you that the lawyers has to reproduce those judgments, number of pages that get wasted, number of electronic copies that they are making, and at times the electronic copies get uploaded on the websites of the courts after a delay of some time, and usually the lawyer require a hard copy which he or she gets from the court, which is called a certified copy from the court of law, because wherever you will adduce that copy, it has to be a certified copy, unless the subservient court or any other court of appeal for that matter shall not give it shall not give it a value, or the veracity of the same may be contested. So the certified copy is required each time. So in that case, if the AI tools are used for making the analysis, quicker analysis, as well as uploading or making the judgment available and accessible to the people in a brief manner, then they will not require voluminous number of judgments to be reproduced in hard bound manner, right. Then delay in judgments due to manual work, obviously the lawyer who has taken a brief from a client, he needs lot of time to prepare the matter, and he seeks adjournment every time, because he is having lot of other cases also listed in the courts of law. And these days the modern court law practice is very competitive, where the lawyers are running from pillar to post to serve their clients, and so delay is occurring, or it occurs. So to preclude that delay, we can use such tools which are based on these new technologies. As per the records of 2022, over 4.7 crore cases are pending in courts across different levels of judiciary. Of them, 87.4 are pending in subordinate courts and 12.4 in high courts. Well, as high courts are purely appellate courts, so that is why you see the lesser number of pendencies there. But when it comes to subordinate courts, which are basically first instance courts, here you find lot of cases which are pending, because every now and then people do file a case in the subordinate court, and the subordinate court is the most ill equipped and most poor in the infrastructure, right. There are no adequate number of manpower, there is no adequate number of manpower employed in the subordinate courts in the far flung areas in the country. There are not even adequate number of subordinate courts available in the far flung areas of the country. So in such a scenario, use of the technology can help, and it definitely can address such concerns of pendency. So this challenge of pendency, as well as time consumed and cost inefficiency, may be addressed by the AI tools to a great extent. What are the positive implications of using AI? Where there lies a scope of the AI in the judicial field or in the justice delivery system? If we look at the positive implications, this can help cut down on the amount of cases that are waiting in Indian courts. Judges and solicitors can easily analyze, evaluate, interpret data, and as a consequence, disputes may be settled more rapidly, cutting down on the amount of time needed to resolve cases, which can save the court money and lower the expense of the litigation for the public. Well, public these days are being duped by unscrupulous lawyers also, or they are cheated by the unscrupulous lawyers who take money and do not represent them fairly. So this kind of a system, weak weakens the trust on a particular profession. So to avoid that and to definitely reduce that kind of a culture, it is needed that such technologies must be made mandatory, and some steps should be taken which have been taken by the Supreme Court in some of its projects, which I will discuss and highlight shortly, but they are not adequate because subservient or the subordinate judiciary is yet to see the changes or the implementation of such tools. When it comes to efficient decision making, AI can look at a lot of data and analyze trends that human specialists occasionally overlook. Judges and solicitors can provide more accurate outcomes by making clear and informed decisions. So another important aspect or feature of the AI tools in the field of law is that they do not overlook the things, rather they give the exact or impeccable data and analysis which the humans cannot do. When it comes to efficiency, AI powered systems can analyze massive volumes of data quickly and accurately, saving time and effort on the legal tasks. It also saves a lot of money, and routine legal tasks like document examination analysis can be done with the help of these tools. Proceeding further to the challenges, apprehensions in the use of AI, or which are some of the probable cons, you may say, right, of the technology called AI in the field of law. It is one of the cons is the biasness. It is said that the systems may enforce prejudicial attitudes already present in the legal system, producing biased outcomes, and this is especially true in India, where the legal system already treats marginalized communities unfairly. Analyzing the training data and technique employed by AI system in detail is crucial to lowering this risk. So this is really very important, that there may come a bias because of the technique employed in feeding the AI or in commanding the AI, or in making it workable. But this is something which lies even in the human or in the case of the humans, where the human lawyers may commit some bias, or the judges also do the bias or prejudice to a particular litigant for a particular reason, like caste, sex, race, creed, ethnicity, etc. So that is something which in the case of humans will be very difficult to be avoided or escaped, but in the case of machines, if we want to lower this risk, we definitely need to employ such techniques which are not preordained with some biasness, right. Then AI systems are frequently secretive, and because of which there is no transparency, making it challenging to comprehend how judgments are made. The judicial system may become less trusted as a result of this lack of openness. Well, transparency is a key feature, because law predominantly runs on transparency, or the justice delivery system runs on transparency. You must have heard about the adage or the maxim which is very popular in the field of law: let the other side to be heard and let the other side to know as to what is happening. And this is something which is a prerogative and right of a litigating party, to know the rights and duties of his or her contesting that battle in the court of law. But since the system which they are using is based on or the technological system which they are using is based on some sort of a predetermined program, or you may say it's secretive, which he or she does not get to know. So in that case, knowing the particular way in which it functions is very difficult, and the normal users of the AI cannot be told as to how it functions, and they may not even comprehend or understand it. Now there is a limited data or availability of the data in the legal field. This is the most challenging issue when it comes to use of AI in the field of law, that there is a limitation on a data available. There is rarely a digitization of the judgments in the past, or there used to take place no digitization of the judgments in the past. It is a of late scenario when every judgment is digitized, and most of the laws are digitized, but in the past it was it was paper bound or paper based. So, there is limitation of data, and because of which the AI tools can't function the way they are expected to function. They require set of instructions, they require data, or they require repositories to function properly, especially ML model, the machine learning model approach of the AI requires some patterns. So, patterns will come only when there is a base or digital base on the basis of which it functions or on which it functions. So, that is missing. Then there are some ethical issues like the artificial intelligence or its employment in civil disputes poses ethical issues related to privacy, autonomy and accountability, but these may be avoided with, or some responsible steps may be taken to avoid it. Then there is a myth about job losses, which I believe is not correct. If you look at the disposal of the cases in the different courts, in the institutions across different courts or different judicial system in the country, so it is basically very shady, or you may say not so encouraging, but it was only in the cases of you may say the particular usages of the AI wherever it was done. It is a study which has been done by the EU or European Union, wherein they saw a surge of disposal of the cases in the cases of usage of the AI. Then AI systems used in the legal field around the world. This is also important, my dear viewers, to see what kind of AI systems are used around the world by the law, by the legal machinery, or by the lawyers, by the legal fraternity. We have some legal tools or AI systems tools which are very popular, like we have Ross Intelligence developed in 2014 at the University of Toronto, and it is the most advanced technology of natural language understanding. It allows you to ask your legal issues or describe the facts and procedures to the system in natural language instead of using Boolean terms or keywords. So, it has a speech recognition, and you may speak and describe the facts and procedures of facts of your particular case to the particular system, and it accordingly helps you, because it is the most advanced technology of natural understanding, language understanding. Then we have Kaira systems especially designed for recognizing, extracting and examining clauses from contracts and various other legal documents. It saves 20 to 60% of time for first time users and saves around 90% time for the experienced ones, and it reviews the contracts with 100% accuracy, automatically highlighting and extracting the related text within seconds. It is designed to review contracts basically in different languages such as Spanish, French, German, and can learn new languages as well. So, it is a tool specifically to review contracts and extract, examine clauses of the contracts. So, it may also be used in India, but the use of this particular system is rare in the country, because our contractual law is different than their contractual law, but we may customize it according to our needs, or we may develop a similar model, customized model for our our problems or our contractual arrangements, wherein our contract law shall be fed to the particular system. Then eBrevia, which is developed in 2012 by the Harvard Law School graduates, used to find out relevant text from various long and complicated legal documents and contracts within a very short period. This uses AI and advanced machine learning to identify and extract content from contract and makes a summary report to that extracted part. It saves lot of time, it can extract important information from a contract, customize that extracted data and present it in a Word, Excel or other database. So, this is also a very interesting tool which is used for complicated legal documents or their analysis, especially for the analysis of the contract contractual arrangements or contractual documents. LawGeeks was developed in 2014 by Nuri Becher and Ilan Edman, a contract review automation solution. So most of these tools, if you look carefully and if you are seeing the pattern, are on contract or solutions to the contractual arrangements to manage, review and approve daily contracts of the people. It resulted in the reduction of human errors, and this helps companies' legal team to concentrate and work on more important legal matters. So these mostly are on contractual arrangements, but there can be similar customized tools for catering to other fields of law as well, except this contract, because there are many tools available on the contract. Then we have Factio, developed by a Chinese company named Wusung in 2016, mainly to analyze a case and then to recognize the type of case, and it provides best possible ways to solve the dispute. It helps people in choosing the best attorneys that are ideal for representing them in court. It also helps suggesting, but here lies a chance of biasness, that it only suggests those attorneys which are at the high priority, or which are usually chosen, right, because it develops a pattern or it is based on a pattern. Then we have Xiao Fa, introduced in the courts of Beijing to provide legal services to judges, litigants and court officials, and it is a very big tool, explains the legal matters in a child voice. It is manufactured to explain complicated legal matters and legal definitions to people in very simple language. It helps in reducing the cost of litigation, improves the efficiency of justice system. What are the applications of computer technology in legal field in India, which we are seeing? So for understanding this and then coming to the AI or use of the AI in the Indian context, we need to understand what kind of a projects our judicial system has started or initiated in the direction of using ultimately AI tools or AI systems for disposal of the cases, for dispensation of the justice. So we have e-courts project, which was conceptualized on the basis of national policy and action plan for implementation of information and communication technology in the Indian judiciary in year 2005. So it is something very old, in the context of India, that we had a e-courts project of the year 2005, and it was submitted by E-Committee of the Supreme Court of India. It is a pan-India project monitored and funded by the Department of Justice, Ministry of Law and Justice, Government of India. It came into the phases and there came 3 phases. 1 and 2 had dealt with the digitization of the judiciary, e-filing, tracking cases online, uploading judgments, etc. Then phase 3 plans to upgrade the electronic infrastructure of the judiciary, where we are thinking of converting the existing judicial system into virtual court system, and a court system which is broadcast live. Then the e-courts project was conceptualized with a vision to transform the Indian judiciary by ICT enablement of courts. This e-courts committee of the Supreme Court of India recently released its draft vision document for phase 3 of the e-courts project. The Supreme Court has directed all the courts to extensively use video conferencing for judicial proceedings in the wake of the pandemic, and in May 2020 the Supreme Court introduced a new system of e-filing and artificial intelligence enabled referencing. So we see that the Supreme Court in 2020 has introduced artificial intelligence enabled referencing, right. It is already in place and it is being used, but not many lawyers and not many clients are aware, even the judges in the subordinate and the subservient judiciary are not aware. They may use these tools and accordingly make their work faster and simpler and efficacious, right. Then use of technology in the legal field in India, if you see, or specifically the AI technology in the legal field in India, we see AI portal for Supreme Court, which is called SuPace. Supreme Court portal for assistance in courts efficiency, and it has been launched to enhance the productivity of the legal researchers and judges in India. So PACE is a AI enabled assistive tool that can augment the efficiency of the legal researchers and judges to work on cases, extract relevant information, read case files, manage teamwork and draft case documents. Then AI systems to read legal judgments. Here IIT Kharagpur researchers have developed an artificial intelligence aided method to read legal judgments, which can not only tell which laws are getting violated, but also in the process help minimize legal costs. So AI is or use of AI has started already in the country, specifically with the AI powered portal SUPACE of the Supreme Court portal of the Supreme Court, which is called Supreme Court portal for assistance in courts efficiency, and its idea is to empower the researchers and the legal professionals, the judges, the lawyers, etc., in enhancing their productivity, because this assistive tool can be used to do the efficient legal research, as well as to work on the cases and extract relevant information from the voluminous data. Then Supreme Court judgments have been made available in vernacular languages by its software called SUVAS, which is Supreme Court Vidhik Anuvad software. This is a machine learning tool and is being used for translating Supreme Court judgments into vernacular languages, and the Apex Court has already started translating and ruling into 9 Indian languages such as Assamese, Bengali, Hindi, etc. Then for summarization, automatic summarization of legal case documents is also being done, and several algorithms have been developed specifically for summarizing legal documents. One of the projects that I was involved in with the Computer Science Department of University of Delhi was specifically meant to, or aiming to summarize the Indian legal judgments, specifically the IPR judgments or intellectual property rights judgments delivered by the Delhi High Court, and it was a year-long project wherein we annotated and summarized and classified lot of judgments in the field of intellectual property. The next stage of that project is about to begin, wherein our idea is to expand our work and make it more inclusive by not restricting it to only IPR judgments, rather making it more expensive in nature by including other fields of law as well. So there are many uses of the AI in legal field. You can have a quick look at this slide and understand that what can AI do and what miracles it can do. It can predict outcomes, generate automatic pleadings, it can do document review, it can classify and group documents, it may perform different administrative functions, grant bail, parole, probation on the basis of a particular pleading, and settle the cases based on predictive analysis, and so on and so forth. There are multifarious ways in which the AI is working in the legal field. When it comes to case laws, in the Indian courts, we have seen that a couple of cases have come. The Delhi High Court in Christine Louboutin versus Messrs Shoe Boutique in year 2023 asserted that in its present state of technological development, AI cannot replace human intelligence in the adjudication process. It emphasized that responses from AI chatbots cannot serve as the basis to adjudicate legal or factual matters in a court of law. Delhi High Court concluded that ChatGPT cannot serve as the basis for adjudicating legal or factual matters in a court of law. This is because, firstly, the response from the large language model based chatbots like ChatGPT depends on various factors, including the nature, structure, training data, etc. Secondly, there are possibilities of AI chatbots generating incorrect responses, fictional case laws, imaginative data, making the accuracy and reliability of AI generated data a grey area. But on the contrary, in contrast, High Court of Punjab and Haryana recently employed ChatGPT in a case to determine bail jurisprudence in the case of Jaswinder Singh versus State of Punjab. In this case, the court asked the following questions to ChatGPT: what is the jurisprudence on bail when the assailant assaulted with cruelty? And in its order, the court specifically mentioned that any reference to ChatGPT and any observation made herein above is neither an expression of opinion on the merits of the case, nor shall the trial court advert to these comments. This reference is only intended to present a broader picture on bail jurisprudence where cruelty is a factor. So it has used the ChatGPT, which is a large language model, and it has categorically categorically mentioned in the judgment that it must not be made a precedent that the courts can use the ChatGPT, but the observation was given that it is something which is giving a jurisprudence on the chat GPT when it is asked to give the jurisprudence on the chat GPT. Then there are a couple of limits of AI in legal field which we have already discussed, but I am discussing it again because this is the most important challenge that the things are not digitized, or it requires a lot of data, it requires patterns or rules, and in the legal field there are no specific patterns of writing judgments, of writing laws, or of law making. So in the absence of some uniform patterns, or in the absence of unequivocal patterns, it is very difficult for AI to efficaciously work in the legal field. Then no cent% accuracy, everything can't be converted to data in the field of law. Not everything can be converted into field of data, because law is a societal discipline which is dynamic, which is living, which is everywhere. You see its application everywhere in different fields and in multifarious dimensions. So this myth that AI can replace the lawyers is busted, and you cannot say that AI will tomorrow replace the lawyers, because AI to develop to that extent where it can replace the lawyers will take centuries, because the data which it requires, or the patterns it requires, are absent in the case of legal field. This tool or these devices or these systems, AI systems, may be of great use, but they can't ever replace the humans or the lawyers especially. It is just in early days of the AI in the field of law. It will take a lot of time for it to develop and to come to that advanced stage of replacing the humans, or thinking of replacing the humans. Then when it comes to IP law, intellectual property law, because the AI scope lies everywhere, in the field of civil matters, in the field of criminal matters, as well as in the field of contractual matters, or simultaneously it applies in the field of IP law. But when it comes to IP law, there is a specific mention which is required about the intellectual property laws and the AI or their interface, and I have a lecture articulated for you in this series, which will focus specifically on AI and IP law. But for your brief understanding at this juncture, or during this lecture, to arouse your interest in this field, let me tell you a lot of things which are which are AI, or which are technologies in the AI are IP protected or intellectual property protected. And there is a opposite concern, right, which is that sometimes the AI generates a lot of works, like a pleading prepared or a draft prepared by the AI. So who will gonna own the copyright or intellectual property on that pleading or that draft in the field of law? And if the AI argues or becomes an arguing counsel in the court of law, who will gonna have the right over the performance? Because the lawyers who perform or who actually argues in the courts of law, they technically have the performance right under the copyright law or under the copyright regimen. But what will happen with the arguing counsel, which is AI or a robot, or what will happen, or whose right it will be on the particular draft or a pleading prepared by the AI tools. So such concerns are arising or will arise. So can AI technologies be subject matter of protection under IPR? Yes, definitely. We all know that they can be subject matters of intellectual property protection, because they are the technologies or innovations. Can the results produced by AI be a subject matter of protection under IPR? So this is the concerning issue, where we see as to what will happen. Who will gonna own? The ownership issues will arise, or issues pertaining to title of a particular property will arise, and what are the challenges as to the protection of AI under IPR. So when it comes to trademark and AI, viewers, the AI can get a trademark protection, the name of a particular AI technology, like we just came across some of the AI tools used or being used in the different jurisdictions in the world, in China, in Toronto, in in America, in EU. So they, according to the niche classification in the trademark, which is an international standard, right, they fall under class 9 and class 42. So, anyone who has developed a AI tool which helps in the legal discipline, they may get the trademark protection of that particular AI tool by giving it a name, by giving it a any letter, device, logo under class 9 and 42 of the Trademarks Act. Then can AI system infringe on trademarks? Yes, it can infringe on the trademarks because at times it may develop some deceptively similar or confusingly similar marks with the earlier existing trademarks of some proprietors, and in that context AI may infringe the trademark. But who shall gonna be bear the liability of infringement, that remains a grey area, or that remains a the topic for discussion. So, can AI system cause confusion among customers? As I said that AI is being used for lot many things, for manufacturing as well. So, any product which is prepared, or for packaging as well, AI enabled machines or AI systems are used. So, it may also confuse the customers. The AI systems alter the behavior of consumers. Yes, they do alter the behavior of the consumers. To whom does the trademark or slogan suggested by AI tool belong? So, when it comes to ownership, if AI has been used, suppose a trader, a local trader, or a business service provider, or any service provider for that matter, has referred to AI some tools which are suggesting some creative names to be registered as a trademark. So, in that case, who will gonna have the trademark protection of that trademark which has been suggested by the AI, which has not been coined by you, or which has not been propounded by you, rather which has been suggested by the AI. So, to users who enter the command, the ownership will lie, or to the AI tool owner the ownership will lie, or to none. So, these are some of the perplexing questions. Then in the case of designs and AI as well, we see that there is a requirement for protection of designs of certain things, but designs may be produced with AI assistance or autonomously by AI tools. So, who will have the protection on intellectual property protection on such designs which have been produced by AI assistance, or which have been autonomously produced by AI tools? So, how AI can impact design law? Can results generated by an AI tool could be protected as a design, and who should apply for the design, the user or the developer of the AI tool? And some copyright issues will also arise, because while creating a design, the AI might breach somebody's artistic copyright, or somebody's artistic work where the artist enjoys the copyright protection. So, copyright issues may also arise. So, ownership in the case of AI, or specifically AI assistance outcomes is debatable, is yet in is yet unclear. Then copyright and AI, in the field of copyrights, we all know that the copyright is given to the literary, artistic, dramatic, musical or sound recordings, etc., or cinefilms as well. But when it comes to literary work, suppose the AI assistance has been taken by some author in writing a literary piece, who will gonna get the copyright protection? Then at certain occasions, the idea expression dichotomy also occurs in the field of copyright and AI, or their interface, and whether the work shall be termed as original, which has been created by AI, or not so original. It all depends, because as of yet no clear guidelines or no clear cut answers are available to such questions. Can AI algorithm be protected under copyright law or trade secret? Where will it get protected? This is again a problematic or grey area. So, answers to these questions are yet to come from the experts, as well as from the best practices prevailing in different countries or different jurisdictions. But to make you understand that AI issues may arise anywhere or everywhere in the field of law, be it a civil law or a criminal law or a intellectual property law, or for that matter contractual law or a tort. Everywhere the AI has its usages, as well as its some cones which are putting across lot of challenges to the legal fraternity and the scientific community. So, both has to come together. Even in the cases of patents, computer programs patentably, at some places they are patentable, at some places they are not. When it comes to computer programs, countries like US, they grant software patents on the computer programs, but in our country, computer programs are copyrightable, they are not patentable. But patentability of a computer program is not harmonized across jurisdictions. It is vary from jurisdiction to jurisdiction. In one jurisdiction it might represent a patentable subject matter, while in other it could be excluded. So, the requirement of a direct technical effect exists in all of them, as well as the one of an inventive step. And it is also necessary that the computer program which you have evolved, which may be tomorrow used as a in making a AI tool, has to have an inventive step or has to have some non obviousness in it. So, in general AI is viewed as a tool, not as a system that can invent, but there might be tools that invent or that can invent. What will happen to that tool, those tools, or that generative AI tools or assisted tools, where they will invent on their own and seek the inventorship or claim the inventorship. So, the current policy on AI and law is basically focuses on or should focus on, because the policy as it exists today has challenges in the form of some grey areas which I just discussed. So, the scientific community or the legal fraternity or the policy makers of a particular, both these disciplines, they must keep in mind all these factors. These are automation, these are what if AI starts deciding on rights of humans. In this series there is one topic or one interesting lecture I will deliver on advanced robotics and human rights of the robots as well. AI decision making is reasonable or interpretable in adversarial system or not. It is highly abstract and highly mechanical, so conferring legal personality to AI or not is a question, is a matter of debate. Then human emotional intelligence, problem solving, policy analysis are less susceptible, but machine may be more susceptible. So, it is imperative for the policy makers to keep all these factors into mind while creating the policy pertaining to AI and law in the country, and some more issues which they must keep in mind, which are written here on this slide. In the specifically in the cases of legal field, right, where the legal AI tools are created or generated. So, all such issues should be kept in mind, that truthfulness has to be there, someone should be made liable, and there has to be transparency, and the machine should have emotional acumen which makes a report or a physical contact with the particular client, right. So, with this I will come to the conclusion because of the paucity of the time. So, the legal sector in India is one of the largest, is highly under digitized, and given its very conventional and traditional approach, the field of law in India seem to be very skeptical of adopting new technologies like AI. While the legal profession is not immediately threatened by the advent of AI, the legal sector will await some major technological overhaul to smoothen the system, and Supreme Court has taken certain initiatives which we discussed. To sum up, artificial intelligence is no more a futuristic idea, but a reality, but it is at its early stage in the field of law. The word in the legal field or in the field of law, the word is on the point of transition, but in the field of law it is at an early stage. So, for justice delivery, AI is necessary or can become a very necessary or very helpful tool, because it will enhance the way we think or perceive things and change the outlook by exploring new horizons from space to oceans. It will bring a revolution in mankind and can become the most powerful and dominant human innovation in the history. But in the field of law, as I said, it is at an early stage, and it may time to develop to that level where it can serve its best or in its best way to the legal fraternity or to the legal professionals, including the judges, lawyers and the litigants who are basically the parties of parties contesting the cases in the courts of law. With this, I conclude my lecture, and I am hoping and looking forward to meeting you again with some interesting lectures in this series called Law, Science and Technology. Thank you very much, viewers.